Ladies and gentlemen, welcome to this episode. I'm doing the Tom Munns intro. Well, today we have a really special guest, and I'm excited to have this guy because aside from myself, he's the other guy that understands this issue really, really well. And without his research, there's a lot I could not have included in the book. And of course, he proofread every version of the book, which is 5 or 6 different times that he had to read the thing all the way through. And he gutted it out and he ground it out. And this guy's amazing. He's just, if I have a high level legal situation that I want to discuss with somebody, this is the guy I go to. So without further ado, I want to introduce Dave Erlanson. And Dave, could you tell everybody a little bit about yourself? And I really, somewhere in there, if you could tell them about your case as well and kind of build up to where we're at right now.
Okay, I got involved as a gold prospector in the federal government's intervention on the mining aspects within the federal lands in about 2009 when the U.S. Environmental Protection Agency did a biological opinion on dredging, suction dredging. That's a method of getting gold out of the streams in the state of Idaho. So I did that. And in 2013, the EPA developed what they called a federal 402 MPDS permit in the state of Idaho, and I might add, without any legislative approval. That was followed up in the following year. But in 2013, they came up with this general permit program. They were able to obfuscate basic federal government regulations like the Administrative Procedures Act because they said this isn't rulemaking. They said it's a permit-based deal. But the problem is that permit had many rules and regulations that followed, and that concerned me. And in 2013, I stayed off of the South Fork of the Clearwater River, where I held federal mining claims. 2014, I stayed off that river. In 2015, on I believe the seventh day or the sixth day of the season, I went up to find about 30 dredgers dredging. I was shocked there was that many people there, and so my buddy and I set up camp. The Forest Service rode by, and the next day they came up and they took pictures. And a long story short, it led to a 9-year legal confrontation with the U.S. EPA, the Administrative Court System, the EPA Appeals Board, the United States District Court, the Ninth Circuit of Appeals, and finally, in the last 2 months, with Ron's help from a July writ of mandamus, of which I took out portions, I put in a writ of mandamus to the Supreme Court of the United States. And at this time, apparently it's in the hands of the Supreme Court because I have not received any paperwork from the Ninth Circuit or the US EPA, and both responses were due by April 1st.
Hey, Dave, tell people what that writ is, please.
Writ of mandamus is it's a legal document what you're doing is you're asking a higher court to order an inferior court, a lower court, to make a decision, either one way or another, not for or against the defendant, but to make a decision. And the Ninth Circuit didn't make a decision. We appealed. Ron and I wrote an appeal. We sent it into the Ninth Circuit. I believe it was in November. It was either November 6th or 8th of 2022. And so I told Ron, when I get back from hunting in Pennsylvania, we're going to get this writ going. So I took his template that he had and added a bunch of legal stuff to it and a bunch of case studies, and I sent it in, and the Supreme Court took it. And That's where I'm at with that case. But one of the cases that I really believe, because this case is personal to me, the other case, I'm on the board of directors of the Mount Pisgah Mining District in the 10 Mile Mining District, and Ron knows very well the 10 Mile Mining District. And so I was asked to write paperwork to promote a water right issue within the state of Idaho on the forest and BLM reservations. And quite frankly, I was looking at research devoted to that because I have a meeting with an attorney tomorrow. And so over the weekend, I was looking at that and I came up with something that was very astounding. And I couldn't wait to call Ron and tell him about it, because all this time, with Ron's book, with some of the things we asserted in my court case with the EPA, dealing with the jurisdiction of federal lands in the West, we believed, Ron and I both, that contrary to the existing law in the United States, that the federal government was actually using exclusive jurisdiction. But we could never find it written out in plain English that that is exactly what they're doing until Sunday morning. And on Sunday morning, I came across this and I was very, very surprised at what I saw. And I called Ron and I says, we've got the proof. And since that time, Ron also found another proof. Now, this has been 8 years and could never find the proof. But we both, me more reluctantly than Ron, agreed that it could be the only scenario where the federal government could come in and deny a person their constitutional rights. And so I found the proof. Ron can get on, he can ask me, and I think the thing to do here would for me to actually show the people the paperwork I found, and then explain what the paperwork says, and then show them how the government is violating their own laws on the jurisdiction.
Well, let me ask you really quick, your understanding of this exclusive power, what is the main problem that it creates in these federal areas? Can you explain that to everybody?
Well, if the government is asserting exclusive jurisdiction, as it says in the Constitution, they mention the seat of government, Washington, D.C., where the Congress of the United States has exclusive jurisdiction over that, not the president, not the courts. It's Congress, it's the legislative branch. They have exclusive jurisdiction. Which means that if the federal reservations, and I'm just going to talk in terms of the state of Idaho, if the federal reservations, by that I mean the U.S. Forest Service and the Bureau of Land Management properties, are under that designation of exclusive jurisdiction, and I can read, I believe, from right here, I'll give you the definition of exclusive jurisdiction. And I'll give you the definition here in just a second. I have to get into this. By the way, exclusive jurisdiction is basically federal enclave jurisdiction, if in case anybody's interested.
I can't find that attachment I got. Wow, that was weird.
Yeah, that is weird.
What that I ended up receiving something from you guys, and I can't for the life of me remember where it was. I was going to ask you to do a screen share, but I was going to do one if you didn't, because I thought I had it, but I don't have it. So,
Well, I've got some papers here. Here, I can show this to the people. I don't, and you'll have to tell me because my screen up top is it's shrunk basically since we've been
a
talking.
little higher.
Okay, can you see what that says on the top?
No, pull it back a little bit. Okay, law school, state and county run police activities, 4 types of legislative jurisdiction. Number 1, exclusive legislative jurisdiction, federal enclave. Exclusive jurisdiction is the term applied when the federal government possesses, by whichever method acquired, all of the authority of the state, and in which the state, and that's all I can see. Go up.
Okay,
Okay.
what it says here, and in which the state concerned has not reserved to itself the right to exercise any authority on the property.
Right.
Okay, that's exclusive. Now, what you have to realize is when that means that the Congress of the United States has the exclusive jurisdiction. The state has nothing. But here's the problem, Tom, and you have to understand that exclusive jurisdiction, here's the next branch of jurisdiction. And it's called concurrent legislative jurisdiction. I don't know if you can see that or not.
Somewhat.
Can you see it now?
Yeah, go up. Go up more. Up, 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 up. All right, there. Stop. Concurrent.
Okay.
Yeah, go ahead.
So that's the second classification of jurisdiction of the federal lands.
Okay.
It's very important to know that the federal lands are divided into 4 jurisdictional categories. Concurrent legislative jurisdiction is the term applied to those instances wherein granting to the United States authority, which would otherwise amount to exclusive legislative jurisdiction, the state concerned has reserved itself the right to exercise concurrently with the United States all of that authority. Now, there's the third one. There's the third one. Aha, I see Ron has sent that to you. That's very good. The third one, Tom, is partial legislative jurisdiction. Partial jurisdiction is a term applied to those instances wherein the federal government has been granted for exercise by it over an area in the state, certain of the state's authority, but where the state concerned has reserved itself the right to exercise concurrently.
Okay.
With
Is that Ron where you were talking about where the if the federal government has extended private rights? Is that what you're talking? Is that what he's talking about?
Well, go ahead, Ron.
You're off. You're muted.
I can't hear you.
Okay.
Can you hear me now?
Yeah.
Okay. No, the extension of private rights into an area really alters the scheme dramatically.
Okay.
What Dave is trying to tell you is all different ways that the federal government can retain some sort of jurisdiction that still displaces private rights.
Okay.
Okay.
I'd like to get the link for that so I can post that in the video chat if I can.
Well, this, I can show you the document.
A link that's on the screen.
Keep going. Okay.
I can show Tom this if you can see it.
Yeah, that's the thing I got in the email that I can't seem to find.
Okay. That's where I'm getting this information.
Okay. Can you email that back to me? And maybe
Well,
I can put a Dropbox in the video or whatever.
I'll take care of that, Dave. I'll make sure he gets a link to it all
Okay.
and gets all that.
Sorry to interrupt. Keep going.
Okay, so now we come to the most important part, and it's called proprietorial interest jurisdiction right here. And the deal is on the federal lands in the state of Idaho, and I have it right here. You made a note of it. It's the inventory report, June 30th, 1962. Now, I'm going to show you something here. First, I'm going to read what proprietorial interest only means. Proprietorial interest only. proprietary jurisdiction. The federal government has acquired, this is so important for the people that are viewing this to understand. The federal government has acquired no form of legislative jurisdiction over the federal lands within the state of Idaho. I'm going to read it again. The federal government has acquired no form of legislative jurisdiction over the federal lands in question. Those instances wherein the federal government has some right or title to an area in the state, but has not obtained any measure of the state's authority over the area. In other words, the state controls the jurisdictional aspects of this property legislatively, not the federal government. So a good question is to ask, how does the federal government make rules and regulations concerning a property? They make it under the United States Constitution because they have the right to protect the assets of the United States under 432. So that's where they get it. Here's
Can I point,
go ahead.
can I point one thing out?
Yeah.
Can we all mute our microphones except for me and Dave? I think that's what's causing our audio problem. I've started muting mine because I think it's just causing a cacophony here. All right, Dave. So, the proprietary jurisdiction. I think we understand now that the intention appears to be there would be no acquisition of the legislative jurisdiction inside the boundaries of the state of Idaho. Okay, got that part. So
Correct.
then the question that I have is how can the proprietary jurisdiction be used by the federal government to also displace private rights and not have it be exclusive?
I lost your audio.
Okay, so my question is, if what you say is true, and I have no reason to doubt it because it looks like it's a legit historical component here. We do know from many people that have been prosecuted in the state of Idaho by the federal agency apparatus, the administrative state, that the problem at large has always been they never had any private rights to be able to assert, and when they brought them up, they were ignored. This has been going on for over 60 years. If they've been able to do that, just using their proprietary jurisdiction, then how is the proprietary jurisdiction displacing private rights? Can we talk to that in a moment?
Well, here's the deal. Regardless of whether the government is under proprietary jurisdiction, or not, the Constitution of the United States in the let me see where it is, underneath the Northwest Ordinance, going back all the way to the beginning, gave transferred rights into the territorial properties of the United States. That was affirmed in the 1897 Organic Act, passed by Congress. You know, it was a law. And it was also in a Supreme Court case. It was shown under point 6 of the territorial doctrine that private rights, if they were, and it was stated in the case, if they were transferred to the territorial property, the constitutional rights, that they could never be withdrawn. What you have today, and I can guarantee it with the next piece of paper I have here, is that you had the federal government operating under an exclusive jurisdiction like they do with DC. They have incorrectly done that. And they have, because of the exclusive right, they you have no constitutional rights. You basically are void of constitutional rights in exclusive jurisdiction areas. That's why a good example, a modern day example, is when the truckers went to Washington, D.C. to protest. You never saw them go into Washington, D.C. They all stayed on, I think it's I-95 or whatever the route is, the beltway around Washington, D.C. Because once they got in there, well, they could be arrested, just like the January 6 protesters, and denied most of their due process rights. And I can tell you that. But as far as the Bill of Rights, and I was reading the Northwest Ordinance today, and it's very interesting. They guaranteed the rights, the private rights of individuals in the territorial property. And like I said, it was reaffirmed in the 1897 Organic Act. So if this is the case, then how can the government deny a person due process? But they do.
Yeah, you're right about that. Wherever we have been able to look at this problem from whatever angle, what it appears to be going on here is that there was never the intention from the beginning of the land program till now for the government to continue using that legislative jurisdiction domestically. And even, in the dissenting opinion by Marshall Harlan in the Downs versus Bidwell case, he's like, look, let's talk about this for a moment, because these are the arguments that are going on at bar here. If that idea ever gets a sanction of the majority of this court,
Mhm.
we will pass from an era of constitutional liberty into an era of legislative absolutism, because these areas are considered legislative. Is that right?
That's 100% correct. And what's done that? What's done that is the rise of the administrative state and judiciary, where, I hear this all the time. Oh, and you hear it on the news. Well, there's two systems of justice. Well, duh. There's been two systems of justice since the rise of the administrative state and judiciary. Because what you have is you have the constitutional application, which is Article 3. Article 3 deals with the constitutional impairments, deprivations, interpretations. That's what Article 3 does. Then you have another judiciary. That's the administrative judiciary. And that administrative judiciary deals with the laws, the statutes, the rules, the regulations that bind citizens. Something that people need to know. And it's all a learning process. So, I didn't know it. And I studied this stuff for years, and I came across it. And people need to know that in the judiciary, you have the administrative judiciary, where they deal with the statutes. That's Article 1. Article 3 deals with the Constitution. I went over that. But if you go to an administrative court and you deal with an administrative law or statute, that is done by elected officials. Say the state of Idaho, say the city of Boise. Those are done by elected officials. And they are in the federal government, United States Code, USCs. But when you get into the CFRs, here's the huge problem that has developed and has metastasized over the course of the last 120 years, which Marshall Harlan, Justice in Downs, warned us against, but not to heed him. This has continued since 1901, and that's why we're in the quandary we are today, is that these CFRs, I'll give you a good example. Congress gave the head of the Department of Interior the head of the EPA the authority to make rules and regulations. Now, that's one person. He's not elected by anybody. He is appointed. And you know, that's the deal. He's appointed. One person. How
Dave,
can
really
one
quick.
person in a
Dave, really-
constitutional republic make rules and regulations that bind citizens? It's
Dave,
against
really
it.
quick. I just want to
Go
ask
ahead.
you a question.
Yeah, go ahead.
Wasn't that grant of power given to the head of the, it was the head of the Department of Interior or the BLM? Which one was it?
Department of Interior.
Department of Interior.
Yeah,
Wasn't that an exclusive grant of power?
yeah, yeah. Congress says you can make all rules and regulations. The American people have to understand this. On this hand, you have elected officials making laws, making statutes. And what is the result of that? That binds the citizens of the United States to an obligation to comply if you're going to do it lawfully. Let's have to say that. On this hand, you have one person, the head of the EPA. You have one person, the head of the Department of Interior, that can make rules and regulations. He's not elected. But what is the result of those rules and regulations? The same as this over here. Both, whether they're statutes, laws, rules, or regulations, bind citizens to an obligation. And if you do not comply, you can be arrested, you can be cited. And that is where Downs versus Bidwell really comes into play, because we have ignored the warnings. And we even SCOTUS in an erroneous decision, in my opinion, in 1928 under J.R. Hampton versus the United States, under the Taft Court, said what's vested in the Constitution, you hear it all the time, what's enumerated in the Constitution, that's the powers of Congress. But not in J.R. Hampton. J.R. Hampton changed the Constitution of the United States. The Supreme Court did. Because they said, doesn't matter if it's vested, doesn't matter if it's enumerated, whatever Congress, they can imply whatever they want. And that was the catalyst that the administrative state needed to get into this huge federal bureaucracy that the American people have no concept or clue of what's going on, because it is so immense and vast. Each one of these agencies makes rules and regulations. Each one of them. None of them are elected. It is the administrative state and judiciary that is the fourth branch of government in the United States. There's supposed to only be three.
Well, let me ask you this, Dave. If you were to try to figure out like a sign of value, let's just say it this way. If you were to try to assign a value, and I asked you something to the tune of how, percentage wise, how much of our current problems with government is emanating from this issue, what number, what variable would you give us?
You talking, Ron, specifically about the administrative state and the agencies of the federal government?
Yes.
It's a very subjective answer I'd have to give, because it would be hard to ascertain a true answer on that. But subjectively, in my opinion, you're looking at 80 to 90% of the rules and regulations are being made not by your elected officials. It's being made by the administrative agencies.
Okay. I would probably have said for myself somewhere around the 80 percentile range. So I think we're in agreement that the size of the problem
It's
is
huge.
large enough to assign such a large value to it. It's like, okay, so then here's the other question. How much of this is is manifesting at the state level? Would it be the same 80%? Or I mean, the administrative problem where the administrative rulemaking procedures seem to somehow bypass the checks and balances of the legislative system. Can you talk about that?
In the state of Idaho, I believe the state of Idaho is run completely as a microcosm of the federal government, with all its ill uh, conceived problems that they've created in and amongst themselves. A good example, it would be the idea that the EPA came in 2007. I know this personally because it happened to me personally. They came in and they were telling the Idaho Department of Water Resources, what permits they could or could not approve. Matter of fact, I have the letter. I just saw it yesterday, and it's addressed IDWR letterhead, the whole bit. And they say, Mr. Erlanson, you did apply for a joint permit to suction dredge. I believe this permit was dealing with it was Kelly Creek up in the North Fork drainage above Pierce, Idaho. And they said, Mr. Erlanson, you applied for the right permit, but we're sorry. We can't issue that permit. Why couldn't they issue the permit? They state right there. Well, it's because you'd be arrested by the federal agency, the EPA. And then they go on to state that you got to get an EPA permit, which there was none available in the state of Idaho. And you have to get a plan of operations from the U.S. Forest Service, who has no jurisdiction over the waters within the state of Idaho. Now, that's very interesting coming from a state agency. So what does that tell you? If you look at it, common sense, it tells you that you have a state agency that is colluding with federal agencies to deprive a citizen of an action. That's what it tells you.
Okay, so let's throw some more meat on that bone. You've got some sort of collusion happening between state agencies and federal agencies, in which the state agencies appear to be exercising federal power. Can you describe to everybody that?
I guess the best description would be the current program that the IDEQ, the Idaho Department of Environmental Quality, has to regulate the activity known as suction dredging on Idaho streams. See, in 2013, like I mentioned previously, I said the EPA came in and commandeered a regulatory program which was being run at that time by IDWR. They came in, they said, hey, look, this isn't good enough. We're taking it over. From now on, you have to have an NPDES permit. The problem is that the legislature in 2005 gave a privilege and immunity to suction dredgers for that exact law permit, and that is active today, and that is listed on the South Fork Clearwater Basin Plan on page 22, and it basically says you do not need an NPDES permit for any type of recreational suction dredge, and I need to categorize that. A recreational suction dredge is a suction dredge with a nozzle size 5 inches in diameter or less. Anything over that, they said you need an NPDES permit from the EPA. So the suction dredgers had a privilege and immunity. Here comes the EPA and says, no, you don't.
Really quick, So you are operating a dredge within the legal parameters of page 22 that was a 5-inch in diameter dredge. And so the law, the NPDES permit situation should not have been applicable to you. Is that what you're saying?
That's exactly what I'm saying. And even today, what happened here is the Environmental Protection Agency came in and took it over. In the interim of that 5-year period, from 2013 to 2018, they cited myself, David Erlanson, and my partner for dredging without an NPDES permit. Even though there wasn't one available, they still cited me, which is another legal deal, hurdle. But anyhow,
Not available, or they didn't exist. There was no such thing.
there was a general permit in 2013, Tom, on April 4th, 2013, and became valid. The problem is in their Federal Register notice of that, they did not exclude the South Fork of the Clearwater River. They said in there that all this general permit covered all the waters in the state of Idaho. In December of that year, they made an amendment to that Federal Register. They published another thing in the Federal Register, another notice, and they failed to mention the South Fork of Clearwater River not being applicable then. So there was no, everybody thought the South Fork was covered. All you had to do was apply to the EPA, jump through their hoops, and you could do this. And follow their rules and regulations, no less. Even though it was a permit, because they made a bunch of new rules and regulations. Now what's happened is in 2018, they knew that I wasn't going to go quietly into the night, to say the least. So I started fighting them, and they didn't want to have any more issues. This is what I believe. And so what they did is they turned the program over to the Idaho Department of Environmental Quality. And so the Idaho Environmental Quality folks took the permitting over for suction dredging. But this is a very, very big problem for me in my intellect. I look at IDEQ as being a state agency of the state of Idaho. Their employees are employed and paid by the state of Idaho. Yet what are they doing? They are acting as proxies. They are doing the bidding of a federal agency because the federal agency knew that they had no authority to come in without legislative approval and put this permit in place, this permit program in place. So you have IDEQ. They have people out in the field doing stream studies, which is all well and good. The taxpayers of Idaho pay these people. But at the end of the week, they submit their paperwork. They submit to IDEQ, but they submit it to the EPA. Why would they do that? That's a good question. I'd love to have an answer. I can't get one, but I'd love to have an answer. But that's just one instance. And they use these state agencies, whether it be IDWR, IDEQ. I'm dealing with these agencies because these are the agencies that I'm most familiar with. And they do a lot of collusionary work with the U.S. Forest Service, BLM, and the EPA, all federal, on memorandums of understanding. The problem is, and I can show you right here, when we look at proprietary jurisdiction, and you had it up on your screen, it's right here. This is the one that you made notice of. I don't know whether you can see it there. Can you see it?
Yeah, we can see it.
Okay. You made note of that. And I would urge all Idaho citizens to write this down or to have Tom check at the end of the video or whatever and write this down and look up the research, become involved. Look this up because it's very, very, very important. And in this, you remember we just got done talking about proprietary jurisdiction.
Leave that on there again or read it because I have its let's see, the inventory report on jurisdiction status.
No, this is different. This is different. This is a different federal document.
Well, the one you're showing me, I'm just reading the title of it.
Yeah.
Of federal areas because I want to
Right.
find it and then post the link on there. Within the states. I have a question too. Within the
Sure.
states, what's the date on that?
June 30th, 1962.
June 30, 1962. The document that he has up is 1969. One of the things that I have found
That's correct.
when I was looking at certain bills was, oh, well, that's an old document. So in your guys' expertise, when we look at a document, how do we know whether this document has been replaced by a newer document or it hasn't, or does it matter? I mean, should there be these types of reports, this federal jurisdiction?
Matters very much, Tom. But go ahead,
Right.
Dave, and see if you can field this one.
Do you know
Okay.
the question? Okay.
Yes, I heard you, Tom.
Okay, thanks.
And the deal is there has not been another inventory report since this that I can find. If there has been, it's not on where the public can view it.
Okay.
But one thing I want to point out here, and it says jurisdictional status of federal land areas. Right here, and it's small print, so I'll tell you what it says. But you can see a list here of words, and then over here there's another column and another column, another column. And I'm going to explain what this is. It says the year that these national forests were founded in the state of Idaho. And it'll say the amount of acreage that forest contains. Then it'll say the jurisdictional classification. Remember the classifications: exclusive, concurrent, partial, and proprietary, 4 of them. They're all under 4, even the Bureau of Land Management. What's that tell you? They can't make any rules and regulations pertaining to that other than under 432 to protect the asset, that property. So if they make rules and regulations where they have no authority, like on the waters within the BLM or the Forest Service reservations, they have no authority over that water. And that's what the miners have in U.S. District Court right now. That's what I'm going to see an attorney about tomorrow, because they are asserting, these federal agencies, that they in fact do have that authority, but they don't. When you talk about my case, and then I'm going to basically answer questions for you guys, if I can. But in my case against the US EPA, does the EPA have authority over the waters in the state of Idaho? I contend they do not. Why? Well, in the Constitution of the United States, the 5-letter word water is never mentioned. So where's the constitutional basis for the EPA to have went into sovereign states and basically commandeered their water? They said, hey, you got to do this, you got to do that, you can't do this, and you can't do that. It's almost the same correlation as Roe versus Wade. They said, hey, you can't have abortion, you can't have abortion. The deal is it belongs in the state's hands. And there's cases that'll bear that out. But what they do is they say the EPA says to anybody that questions it, they say we get our power from the Commerce Clause. Ron and I have spent hours, months of research. And Ron did the bulk.
I think we could. I think we can really, legitimately, truthfully say thousands of hours.
Yes, yes. And Ron took the center section of the history of the United States from about 1824 in a Supreme Court case called Gibbons versus Ogden. And he took it up through 1870. And then I took it basically from 1870 up through the current time. And to try and ascertain where the Commerce Clause gives the EPA authority. Well, here's the problem. Number one, in the people of Idaho, what I'm about to tell you is it's probably going to be very controversial, but it's in my opinion, it's provable because I've got the proof. And so what I'm going to say is in 1970, the president of the United States, then being Richard Nixon, promulgated an agency called the Environmental Protection Agency. 2 years later, the Environmental Protection Agency came out with a revised Federal Water Pollution Control Act, 1948, and they called that act the Clean Water Act. They said that the Clean Water Act was to protect the waters of the United States. That's great. That is, according to J.R. Hampton's case in 1928, the intelligible principle that they said to the US EPA and the Army Corps of Engineers, you guys protect the water. There it is. You got to protect the waters of the United States. Well, in a huge leap of stealing state sovereignty, the Clean Water Act did in fact that, and they said all waters are navigable. Everybody goes, what do you mean? I've got a ditch out in front of my house right here. It's this wide. That's navigable water. How can commerce take place? Navigational servitude. That's what Ron spent hours looking into court cases. How can that term be applied to a ditch? But they did. All non-navigable waters are property of the state. What did the EPA say? Waters of the United States is all navigable waters and the territorial seas. They stole the water from the states, including the state of Idaho, through that regulatory program. 4 years later, or not 4 years later, 4 years later, 1976, basically 1776, 200th anniversary, you know, big time in the United States. In 1976, they stole the land. They stole the federal properties. Everybody calls them public lands. There's the public lands in that mountain and over there. And out there in the desert, that's public lands. That's the BLM property. What they don't realize is the government, in a act called FLPMA, Federal Land Policy and Management Act in 1976, stole all the land. Now, remember what I said. They're supposed to be under proprietary jurisdiction. Those lands are supposed to be under proprietary jurisdiction. And according to the, let me think here, I got to look at it. There it is. I believe it's under the Articles of Confederation, our first constitution, that any type of seizure of that sort should be done by the Congress of the United States. Under 432, they have the authority. But under the Articles of Confederation, there was one aspect that they didn't do. And that is they didn't go to every state legislature and ask for approval. And they had to do that under the Articles of Confederation. Why? Why do people say they had to do that? Or why do I say they had to do that? Because under the present day Constitution, which I'm holding right here, and I don't know what happened to my picture. I guess it's off. I can try and get it back on here. But I'll speak right now. Under Article 6, it says all debts contracted and engagements entered into before the adoption of the present day Constitution, I added that, shall be valid against the United States under this Constitution as under the Confederation, the Articles of Confederation. That's your answer. But in FLIPMA, Congress didn't do that. They refused to do that. So that's where I say they needed to go to the states to take total ownership. See, since the beginning, when the Northwest Ordinance started, and Ron knows this very well, since it started, it was a land disposal program. And it was a land disposal program, even without legislation west of the Mississippi River, they continued to use that land disposal mechanism through the Louisiana Purchase. When it got to the 11 Western states, things changed. And I think things changed because of the Reconstruction Acts, where they basically did unconstitutional things to the southern states. And that's a whole different thing, but I'm going to try and get my picture back on here, folks. In the meantime, you guys can ask me questions.
Well, we got about if we stick to an hour round, we got about 8 minutes, 7 minutes. So if you want to go longer,
Well,
that's fine.
why don't we? Yeah, right. Well, I think if we keep them at an hour, we're doing ourselves a good service. I think an hour is about the amount of time frame people want to divert their attention to it. So
Right.
this has been really good. I know it's been extremely complicated, right? All of the moving parts and all this sort of thing. But this is the method that Dave and I have used to piece this thing together. And this is why anything that comes up regarding this, he's the guy I have to go to because he knows it as well as I do, and we can ping off of each other and try to get some answers to things.
So my question overall, it is really from the position of the listeners and somebody that's kind of like overwhelmed by myself on this topic is, without going into detail, what is the purpose of getting this type of information out to people? What will it help them do?
Well, you want me to take that, or do you want to take it, Ron? Or
Well, why don't you take it, then let me have a response after.
that's a good idea. Okay, so the deal is with the common person. If you are affronted by a U.S. Forest Service Bureau of Land Management personnel, which is the federal properties, and they want to cite you for a violation, understand that you are in administrative court. If you know your constitutional rights and you feel that your constitutional rights are being violated, number one, by going to a tribunal, which is where you go to administrative law judges, that type of deal, primarily. And that's not due process of law, because that's not a true United States court. So you're getting denied due process of law, your constitutional rights, by going to an ALJ, which they disregard your constitutional rights. They may appear to be a true court of the United States, but they're not. That's my takeaway with you need to know your constitutional rights, folks, and you need to know that these rules and regulations that they make pertaining to the forest or on the waters within these reservations are, quite frankly, they're null and void, in my opinion, unless they protect the property itself. That's what I
We
think.
could assume the
Yeah.
same of any agency. So right now I've got a fight with P&Z, and they're the same type of administrative agency, right? I mean, if these states are taking, I don't know, I call it the vassal state position or the inferior position, or they're doing the bidding for the federal government, like you said, what difference really is there if whether they're a state agency? Because for every state agency that exists, there's a federal agency you could say that they answer to, right?
Counterpart, yeah.
So anyway, sorry, I didn't want to get into the weeds on that. Go ahead, Ron.
No, I think you have your finger on the pulse of the problem, right? And I would agree with
agree.
everything that Dave Erlanson said. I think that the reason why people need to understand this information is that when they leave a state protected 10th Amendment area, they need to know what they're getting into, right? So, look, if you're just traveling on the road from one political subdivision to another, chances are really good you're not going to run afoul of this problem. But if you're mining, logging, ranching, and you're not in their preferred class of persons, well, you're gonna run into some trouble. And then the real issue here is you need to be able to identify when the agencies are using powers against you that are unconstitutional. And you need to know how to defend yourself against it.
That's correct.
Amen.
That's correct.
Good. Okay, any final statements, anybody, before we shut her down?
One thing I want the people to see and maybe write down and check. Can you see what I'm holding up?
Yes. I'd have to try to, writing
Yeah,
these
I can see
references
it.
down. So 664 territorial jurisdiction. Ron, do you have a copy of that or a link where I can get that, or do I need to look it up? Jurisdiction. Okay, I'll look that up.
Yeah, and what people want to do there is just look at section 3 where it says all lands reserved for the use of the United States. What are those lands? Those are the U.S. Forest Service, Bureau of Land Management. And that is one of the things that gives them the exclusive jurisdiction that Ron asserted in his book and we asserted in my court case. That is the written documentation. Right up on top there, it says Department of Justice. There's a little insignia on top here that'll say Department of Justice, but it's so small, it's pretty hard to.
Okay, that's fine.
Yeah, but so there's one other one, and I want to leave it go at that. 18, and I want the people to look this up because the more you look this stuff up, folks, the more in tune you are to what we're trying to do here. And that would be 18 U.S. Code at 7. Special maritime and territorial jurisdiction of the United States defined. And that is a very good little document. It's only 2 or 3 pages. And it says basically the same thing as the territorial jurisdiction, but that is United States Code. And remember, that is done by Congress.
Okay, I'll see if I can put all those links in there.
Yep.
Okay, so we're up on an hour, dudes. So if there's anything else, claim it. If not, we're gonna shut her down.
Yeah, I just hope people will take advantage of the stuff and look it up.
Awesome. Well, I appreciate you guys joining me today, Ron. Thanks a lot, and I look forward to our next video. For anybody that's interested, follow us along. You can find these on videos on Rumble, Facebook. You can find them on Spotify, and you can find them on YouTube as well. You can go to Ron's website. He is the author of The History of Federal Lands in the United States.com, and you can click on the vlog page and catch up with the videos there. So, gentlemen, I appreciate it. Thank you guys so much.
Okay.
Thanks, guys.
Thank you,
See you
Tom,
soon.
for having me. Yep. Bye, guys.